Welcome back. This is part two of the video lecture about contempt. So we've been talking about contempt, both in terms of common law contempt, and I mentioned that's kind of a very small part of what we need to think about. The main focus really needs to be strict liability contempt. When we've talked about the Contempt of Court Act 1981 and the basic definition of strict liability contempt being publishing material which creates a substantial risk of serious prejudice or impediment to active proceedings, and then we went on to look at when proceedings become active and when they cease to be active. Another issue you need to think about is if there's an appeal. Of course, if there's an appeal, proceedings become active again. So you need to be really on your toes to know when proceedings become active, cease to be active, and then possibly become active again when there's an appeal. An appeal is only becomes active once the appeal has actually been lodged with the court. It's not just when someone says they're going to appeal, it's when they've actually lodged the paperwork with the court. But because it's very unlikely that you could prejudice a judge, and appeals are heard by judges and not juries, it's very unlikely that you're going to have a great risk of causing a contempt when there's an appeal. But just be aware of it, that a case can become active again even after it's been heard initially by a court. Up until now, I've really been talking about criminal cases, but of course there are civil proceedings going on, and they also there's a risk of contempt. So if there are civil proceedings, remember, a dispute between individuals or an individual and an organisation, then just be aware that those proceedings become active when from the time that a date for the trial is fixed. So that's when they become active, and they cease to be active when the case is disposed of or when it's been dealt with. There's a decision made. And again, during that period of time, you need to be careful. You need to be careful to not to report anything which is going to prejudice that case. There's no jury in a civil proceeding, so like appeals, it's very unlikely that you're going to prejudice proceedings, but it can still be risky if you were to contaminate witness evidence. So you see the process here. It's the legal system trying to protect any possibility that you, as a reporter, as a journalist, can create prejudice. You can suggest someone is guilty. You can make a witness feel uncomfortable about giving their evidence. So that's what you've always got to think about. If proceedings are active, you mustn't do anything which is going to prejudice the proceedings. People will sometimes talk about the phrase sub judice, and it doesn't actually really have a great meaning in British law. But we saw early on with common law contempt that when there is a risk when there's proceedings which are pending or imminent, and that's really what people are referring to when they say that they're sub judice. So make sure you know your law, and then you'll be able to avoid people trying to threaten you away from reporting things which you actually really can report on. So just a couple of examples of getting it wrong. Just interesting to see where other people have gone wrong. We already saw an example just from a week ago of the BBC getting it very wrong and showing some footage from a court case from inside a court hearing. And it's because it happened on video because of the lockdown that they forgot their law and broke the rules of the court, i.e. Opened themselves up to an action for contempt. So this is one. It's a little bit old now, from 2001, but Lee Bowyer and Jonathan Woodgate, quite famous footballers in their time, played for Leeds United, and they were prosecuted after they'd been involved in a night out in Leeds, which had ended up with them allegedly chasing and beating up a man on the streets. And there was a racial background dimension to it, because it was an Asian man that they were alleged to have attacked. The trial took place and the jury was considering its verdict, and that weekend, while the jury was still considering its verdict, so they hadn't come back with their verdict, the Sunday Mirror went ahead and published a great big backgrounder from the family of the victim, and in which it was asserted that Bowyer and Woodgate were guilty, and said an awful lot of other things about them which the jury had never heard before. And this was a clear contempt. They had created a serious substantial risk of serious prejudice in that case, because they'd provided information and prejudice to the jury. So the trial collapsed. The Sunday Mirror was fined £75,000 for publishing that piece, which they admitted they'd published in error. They planned it in assuming that the jury would have been back with their verdict by then, and they forgot to remove it when the jury's deliberations continued over the weekend, and the editor had to resign. So it was a really serious case, and it shows how seriously the courts take these things. Millie Dowler, many of you will know the name Millie Dowler, who was basically at the heart of the whole hacking scandal, where journalists and private investigators were hacking into her voicemails when she went missing. Sadly, she had been abducted and killed, and she had been killed by a man called Levi Belfield. Now, he was accused of a whole series of attacks on other women as well, and when the verdict came back on the Millie Dowler case, and the jury decided that he was guilty of her murder, they were then, the jury had not finished their deliberations. They went back to consider their verdicts on the other charges and the other attacks on women. But the Daily Mail and the Mirror both went ahead and published their background, as they brought in lots of new information about Levi Belfield and the things that he had done, which meant that the jury could no longer be trusted to make a decision just based on what they'd heard in court. So the jury was discharged, and the newspapers were fined. But I always feel that the real cost of this was the fact that those women never got justice, because it was declared a mistrial for their particular cases. So a lot of suffering caused because people didn't obey the law of contempt. Remember Christopher Jeffries? I mentioned him last week. He was wrongly accused of murdering his tenant. Now, see those sorts of front pages that were published. Joe's suspect is Peeping Tom, so they were accusing him of being the suspect and saying that he was obviously some sort of weirdo. The son, you can see there, the strange Mr. Jeffries. They got some background information, and another son headline about him, obsessed by death. This was all before any sense that he'd been charged. It was just based on their suspicions, and you can't help but think it was just because he looked a bit strange. They published all of this, and they were convicted of contempt because they had vilified a witness or vilified a suspect, which meant that witnesses were less likely to come forward. If you remember that definition, substantial risk of serious prejudice or impediment to active proceedings, well, the court ruled that the Sun and the Mirror had created an impediment, because by portraying Christopher Jeffries as a weirdo, that meant that fewer people were likely to come forward in his defence and to act as witnesses for him. So by publishing prejudicial material, even before he had been arrested, they were convicted of contempt. And one I was involved with, remember the Jamie Bulger case, a little boy who was abducted and killed by two other boys, Robert Thompson and John Venables. There was a ban placed by a judge on identifying the location of the children's homes where Thompson and Venables were being held. And we published on the Manchester Evening News, we published a very simple sentence. We said that Thompson and Venables were being held at secure children's homes 13 miles apart in the northwest. I think that's the gist of what we reported. And a judge ruled that because there were only two secure children's homes in the northwest, which were 13 miles apart, somebody could do their homework and work out which two children's homes they were being kept at. And that we had a fine of £30,000, but the costs on top of that, the cost of all the legal fees, came to nearly £250,000 in total. So that's another example of basically getting it wrong and falling foul of the law of contempt. And I promise you, you won't keep your job very long if you land your editor in trouble. The news desk I was working on then, the news editor lost his job as the news editor for that contempt. So how do judges interpret strict liability? Remember, strict liability means that you're responsible no matter what you deem to be responsible for a contempt. So a judge, if there is a potential contempt, they'll say, well, how likely is it that a juror will see the publication? They'll look at the impact on the ordinary reader, because remember, it's got to be a substantial risk of serious prejudice, so they're trying to weigh up the extent of the prejudice. And they're also looking at the residual impact at the time of the trial. So the time when you publish something to when there's an actual trial and there's a jury, it's something known as the fade factor. It's a really important thing, and it helps us as journalists to be able to publish some things. If we publish them far enough before a trial, we can take a calculated risk that the fade factor will help us and work to help us avoid being prosecuted for contempt. Just that first one was very briefly the likelihood a juror will see the publication. Got to think about that. That's used to work when newspapers were printed generally, and people would see your article in a particular area quite often. Of course, now the internet means that the chances of somebody seeing it are very high. So even if it's published in the north of Scotland, someone who lives down on the south coast of England is very likely to see it. So that is less of a useful element for us now. So the fade factor, this is really important. So the length of time between the publication of your article and the actual trial. So that's really important. The longer that time gap, then the greater the fade factor, and so the less substantial risk of serious prejudice there will be. The area where the publication was made, but of course with internet publishing, it means that all publications are everywhere, so that's less useful to us now. And the striking detail which live on the minds of potential jurors. So when they talked about the strange Mr. Jeffreys and obsessed by death, and he was a peeping Tom, those are very striking details, which is why a judge decided that the fade factor did not dismiss the impact, the seriousness of that prejudice in that particular case. There you go. There's Christopher Jeffreys. So even if there's no trial, it's not enough to avoid being done for contempt if you've created an impediment to the course of justice. Demonise somebody like Christopher Jeffreys, that impedes justice. So people stop looking for other suspects, etc. And just to stress, Christopher Jeffreys was completely innocent of the crimes of which people were accusing him of at that time. I'm just going to mention though that you can see how the fade factor works. So this was a case where there was a minor crash between an old gentleman and somebody else, and the younger man got out and he stabbed the old man to death as part of a road rage crash. So you can see that it was. This is published in July 2015. So the stabbing actually happened on July the 16th. And these publications were the following day. So this is a long time before there's going to be any sort of trial, because this is happening right at the start. But those headlines are potentially in contempt of court. If you had published those headlines during the trial, you would have been in contempt of court. So those newspapers have made a calculation that they can talk about murdered for a minor prang. They can suggest that the old man was murdered, and hopefully by now you'll understand the difference between murder and manslaughter, that he was deliberately killed for a minor prang. They can do that at the beginning of the case like this, because they know there's going to be a long time before the case comes to court. So they're relying on the fade factor to protect them. And you'll see here, BBC, they were doing the same thing. They'd rather gone over the top with this little headline, driver murders man 79. So that suggested he was guilty when they reported on that. And you can see they very quickly changed it to Findon murder probe as driver stabs fellow driver. So you can see that sometimes even the professionals get it wrong, and they change things very quickly when they realise, oh, we got this one, gone over the top on this one. So given all this, what we know that that when as soon as proceedings become active, i.e. there's a warrant for someone's arrest or there's an arrest, how do we report on police appeals? So this is a case of Dale Cregan. Dale Cregan was a Greater Manchester gangster and quite famous for having just one eye, and he was involved in a number of murders, gun murders, and then went on the run and then lured some police officers, two policewomen, to a house just north of Manchester, and he killed them. And the police naturally wanted to catch him, and they put up these posters in the city centre to try and find him. But of course, with what we know about the law of contempt, strict liability contempt, I've told you that we shouldn't be publishing extra information. We certainly shouldn't be saying when proceedings are active that there's a £50,000 reward, because that instantly suggests that he's guilty, doesn't it? And if we were to say that the police really want to speak to him and they're trying to hunt him, that again suggests that he's guilty. However, there is a caveat, there is an exemption. So this is another example. Raoul Moat, some of you may remember up in the northeast, Raoul Moat killed his ex-girlfriend's new boyfriend, and then shot a policeman in the face and then went on the run. And so again, that's another tricky one. So there's a warrant for his arrest. So under strict liability contempt, proceedings are active. So therefore, we shouldn't be giving very much detail. So how do you get away with a front page like wanted, and clearly suggesting that he did it, gunman with a grudge? Well, this is how, because the Attorney General has said we've got nothing to fear from publishing in reasoned terms, he says, anything which may assist in the apprehension of a wanted man, and I hope it will continue to perform this public service, says the Attorney General. So what they're saying is if the police issue an appeal to try and catch somebody, then it's okay. That's an exemption where we can start to publish more information than we normally would when proceedings are active. However, once they've been arrested, once they've been caught, we need to go back to the normal rules, and we need to stop publishing prejudicial material at that point. Okay, so that's covered the fade factor and police appeals for information. So I'll stop this one now, and I'll move on to the next one, where we'll talk about defences to actions for contempt.